Signed by then Governor Reagan in 1970, the California Environmental Quality Act, or CEQA, is generally recognized as the strongest state environmental law in the nation. Under CEQA, cities and counties must identify the environmental effects, if any, of most major project proposals and determine whether a full-blown environmental impact report, or EIR, is required to offset any potential harm. If there are environmental impacts, a project must offer a way to mitigate those impacts on such things as air quality, water, traffic, noise, and aesthetics. While this can be done many ways, such as adding traffic lanes, providing open space, contributing to a sewer plant expansion, or downsizing the project, the bottom line is that it adds costs to projects. Proponents of CEQA say that such public input and mitigation is necessary. Proponents of reforming CEQA say that the CEQA process is being abused by businesses seeking to undermine competitors, unions seeking to exert pressure on non-union businesses, and NIMBYs who use it to delay or kill projects they don't like. Does CEQA need reform? We'll ask Sacramento attorney Tina Thomas, a CEQA expert and author of A Guide to the California Environmental Quality Act, Allan Zaremberg, the CEO of the California Chamber of Commerce, and Bruce Resnick, Executive Director of the California Planning and Conservation League, reforming CEQA, trying not to throw the baby out with the bathwater.
From Fresno, the Maddy Report, with Executive Director of the Maddy Institute, Mark Kepler.
Welcome. The California Environmental Quality Act, or CEQA, was signed by Ronald Reagan in 1970 when he was governor, and it's been hailed by environmentalists as a key defense against urban sprawl. Developers and business leaders, on the other hand, often complain that the law results in excessive red tape and drives up construction costs unnecessarily. So what is CEQA and what are the issues? Our first guest is Sacramento attorney Tina Thomas, who literally wrote the book on CEQA, A Guide to the California Environmental Quality Act, and we're very delighted to have her with us today. So let's start getting into the weeds here about CEQA. Can you briefly describe what CEQA is and why it was enacted?
Sure. CEQA is a very important statute. It was enacted, as you said, in 1970 for the purpose of protecting the natural resources of the state of California, a very important goal. Unfortunately, over the years, it's devolved into something a little bit different. It's often used by competitors. It's often used by NIMBYs and those who don't want not in my backyard folks, and often used by labor organizations to get project labor agreements. So its original purpose is still a great purpose, and it does great things.
You know, it's interesting you say that. Right now there's a discussion about outsourcing of garbage services in the city of Fresno, and one of the things that the opponents to the outsourcing are using is CEQA.
Correct. You'll often see competitors using CEQA against each other in the waste industry, gas stations, one big box against another big box. It's not uncommon, but it wasn't the original purpose of the statute.
Well, what projects are subject to CEQA?
So any project that is discretionary has to comply with CEQA. So discretionary means anytime an agency, either a city, a county, a special district, an agency of the state, has to exercise judgment. So if there's not a set of rules by which they must apply, for example, going to get a building permit, you know you have to do certain things. That's a ministerial act, not subject to CEQA. Anything that requires any judgment or discretion is a project under CEQA.
What's exempt from CEQA requirements?
There are two categories of exempt projects. Those that are created by the resources agencies, and they're anything from a project that has a beneficial impact to the environment to the Olympic Games. They could be anything in that range. Or there are those statutory exemptions that are created by the legislature, such as we all know about the NFL stadium in LA. Yeah. Correct. So there's different kinds, and those are exemptions that are created either by the agency or by the legislature. Okay, so why don't you, this is going to be difficult, but why don't you walk us through the CEQA process? Sure. So if you're a city, I'll just take a city as an example, who has a project that's been proposed in their jurisdiction. Perhaps it's a residential project. They, at that point, do what's called an initial study and determine what are the potential environmental impacts of the project. If they can reduce all those impacts to less than significant, they can do a negative declaration.
Referred to as a neg deck.
Correct, a neg deck in the parlance. Or if they cannot reduce those impacts to less than significant, they prepare an environmental impact report, which is a longer form, requires public review periods, and a second sort of iteration, which is a response to comments. So it's just a longer process.
So then there are the lawsuits. So again, let's talk about what prompts the lawsuits. I mean, part of it might be that people feel that there really is an environmental impact here that's not being addressed. But what other things prompt the lawsuits that you've seen?
Sure. There are very legitimate lawsuits that are brought by legitimate environmental organizations that make a lot of sense. And they do things that make a project better. And those are good things. Nobody's trying to stop those things. But there are a lot of abuses that are in the CEQA process, such as we talked about, competitors and NIMBYs. And what we found in recent research that we've done is that 61% of the lawsuits are against good infill projects, or against infill projects. So we're
Describe an infill project just in case our audience
So an
doesn't
infill
understand.
project would be a project within an existing city that's more than likely consistent with its general plan and its community plan.
Okay, so you're seeing lawsuits there as well.
Correct. We're seeing a lot of lawsuits against infill because people don't want more density close to their homes.
When we come back, we'll discuss some of the complaints raised about CEQA. Are they legitimate or are they overblown? That conversation in a moment. This is the Maddy Report. Welcome back. We're talking with CEQA expert and Sacramento attorney Tina Thomas about the California Environmental Quality Act, or CEQA. You know, California's business community has stated that CEQA is detrimental to the economic development of the state. What are their concerns?
Well, I think that there's a fairly significant concern that the statute is so complicated and so uncertain that a lot of people won't come to the state of California and invest in the state of California because of that statute. There's also the concern that these are very lengthy, expensive documents that have to be prepared with expensive mitigation associated with them. But probably the biggest concern is the unpredictability of litigation. If, in fact, you go through a very long environmental impact reporting process and you are sued, you're going to probably be in litigation for 3 or 4 years. It's going to be very expensive. You probably cannot get a loan there. Get a loan on the project, so you're going to be in a situation where the project is essentially suspended until the conclusion of the litigation.
Well, let's talk about this issue of unpredictability. Is that because the regulations and the law are vague, or is it because local jurisdictions have their own interpretation of what constitutes a significant environmental impact or an appropriate mitigation measure?
Well, local jurisdictions do have a lot of deference to adopt their own significance thresholds, and I think most of the regulated community, when they go into a jurisdiction, they know what those standards are, and that's a good thing because they can follow those standards. Where it gets a little bit more unpredictable is that we have all these statutes that have been approved by the legislature that create standards, and in many instances we want to be able to rely upon those and conclude that the impact is less than significant. Makes a lot of sense. It provides clarity, consistency, and predictability. But we end up in litigation a lot of times because opponents believe that you need to do more than what the legislature has asked you to do. And that's where there gets to be a lot of confusion, a lot of uncertainty, and again, a lot of just time loss related to job generating projects in the state of California.
You know, in 2006, the legislature passed and Governor Schwarzenegger signed AB 32, which promised to return to 1990 greenhouse gas emission levels by 2020. How has that complicated the CEQA process?
Actually, AB 32, a very important statute, the environmental groups, hailed as something that was, just a cutting-edge statute in the United States. That 2020 standard was, if we could have relied upon that and used that as the standard and said, we achieved that standard, that's the end of what we have to do, that would have been great. But project opponents went a little bit further and said, no, you need to do more than the 2020 standard. You need to do a 2050 standard or a 2035 standard, or in some cases, a net zero standard. So again, we lost that consistency and predictability when people went outside the bounds of what the legislature had approved.
So they're moving the goalposts.
Exactly.
Okay. There are other environmental laws besides AB 32. How is the coordination between CEQA and those other environmental regulatory processes?
Well, actually, it's not so great, Mark. We'd like to be able to rely on those statutes or on the interpretations of those statutes by agencies such as the California Air Resources Board. So if there is a series of standards related to ambient air quality, we should be able to rely on those standards because they are protective of human health, and be able to rely on water quality standards because they are protective of human health and aquatic life. But again, oftentimes the goalposts are moved.
Well, let's end with this. There's lots of concerns about the legal expenses associated with CEQA. Some say, it leads to a lot of litigation. Others say that's really overblown, and they cite the statistic that only 1 out of 350 situations actually lead to a lawsuit. What's been your experience?
Well, the 350 number is, if you look at any agenda for a city council or a board of supervisors, pretty much everything is a discretionary project, whether it's buying a garbage truck or something as complicated as a development. So, there's a lot of decisions that are made on a daily basis that are exempt or approved on neg decs that just aren't litigated. That's true.
Okay, so there's some of these, there aren't necessarily lawsuits, but still CEQA is impacting the process.
Correct.
Of a lot of these decisions.
What we do know is that there's about 200 to 220 lawsuits a year. That's a lot in my book.
I'm probably in a lot of people's books. Well, I want to thank Sacramento attorney and CEQA expert Tina Thomas for joining us. This is the Maddy Report. Welcome back. The business community has long complained that CEQA stifles development and encourages frivolous lawsuits. Recently, they've had a receptive ear of the governor and key Democrats who control the state legislature. A leading spokesperson for business is our guest, Allan Zaremberg, President and CEO of the California Chamber of Commerce. Welcome to the Maddy Report.
Well, thanks for having me back. It's great to be here and get a chance to talk to your viewers.
Great. Well, listen, what do you see as the biggest problems with CEQA as it currently works, and how do you think they should be addressed?
Well, let me first say, and I give you a little background here, it isn't just the business community. So I can recall a couple of years ago, before this became an issue where Jerry Brown embraced and some other people, is I was giving a talk on the economy of California to the rural counties of California, about 33 of them who are members of this association. And I talked about some of the problems, and then I did a question and answer. And every single Q&A was really a lecture, not a question. And they were all board of supervisors and all from the rural counties. And the number one thing is, when are we going to do something about CEQA? It's killing our job growth. It's killing the ability to develop in the rural areas. And we really need jobs. So this goes well beyond the business community. This is about elected officials who really see a need to grow California. And this is a barrier.
Let me follow up on that. Folks say that when the proponents of reform argue that it's hurting economic development, they say, listen, it's not hurting economic development because, number one, economic development is doing fine on the coast, number one. Number two, that, listen, California's economic decline is because of the housing crisis or the tightness of credit or other reasons, that CEQA is really not the main driver of the economic problems in California. How would you respond to that?
California is a diverse economy, diverse population, diverse industries. So there are different factors that affect different industries. But CEQA, it was clearly pointed out by the rural county supervisors in many locations that this is a barrier to development. So let's talk a little bit about what's wrong with it. And I think we can go into, is this a cause and effect? What's wrong with it is that it's costly and it's used for many purposes to delay projects that have nothing to do with the environment, but blame environmental problems for trying to stop a project. And these are projects, let's be clear, these are things that are going to grow California. So our population is growing 400,000 to 500,000 people a year. We have to find jobs and we have to grow. And if you can't develop, somebody's going to grow somewhere else. So let's be clear about what this is about. And what the problems are with CEQA is that it's very costly. And it's very costly because it's been abused. And how has it been abused? Well, it's been abused because it goes well beyond the environmental impacts and the mitigation. So when you do an environmental impact report, you try to cover every base possible so you don't get sued. And when you just have somebody who doesn't want to see California grow or their neighborhood grow because they already have theirs and they're not concerned about what happens to the quality of life in California, developing a tax base.
Voluminous reports.
Yeah, and then people bring in lawsuits anyhow.
Let me ask you about the lawsuits. One of the arguments on the pro-CEQA side, I guess, is saying, listen, the lawsuit crisis is really overblown. There aren't a lot of people that are filing lawsuits. So if most of the projects go forward without a lawsuit, is that argument of legal costs, is that really an overblown argument?
No, because what you have are the lead agency that has to certify it, requires every possible mitigation under the sun to try to avoid lawsuits. So you overexpose yourself. But I think we have to step back here a little bit and say, what's the difference now and maybe 30 years ago? We have dozens of new laws on the books that create environmental standards that we all have to live by. And, in the whole, it's good for California. And so if a development complies with an environmental standard that was created subsequent to CEQA, whether it be greenhouse gas or land use planning or air quality, why should you still be subject to litigation over that if you've complied and relied on the government standards that they've developed with public hearings?
That's a very strong argument that people on the pro-reform side make. But could that be countered by an argument that would say, listen, yes, it's true, there are all these laws that have happened since 1970, environmental regulations and laws, but they were enacted with the legislature's full knowledge that CEQA was already on the books, and therefore they passed these other environmental laws not with the intent of eliminating CEQA, but rather complementing CEQA. How would you respond to that?
These laws were adopted to set standards, to give business and governments guidance on what the standards should be to protect our environment. If you comply with those standards, that's not what CEQA should be about. CEQA should be about those situations where you may not have a standard, certain traffic where it has to be on a case-by-case basis, certain noise. But, if you have a general plan and it went through CEQA and it had an environmental impact report, you comply with that, and your local air district has adopted air quality emission standards and greenhouse gas standards, and you meet all those standards, when you get sued on that, those people aren't trying to change the environmental rules, they're just trying to stop the project.
Well, I want to thank Allan Zaremberg from the California Chamber of Commerce for joining us. Up next, a conversation with the environmental community. That conversation in a moment. This is the Maddy Report. Welcome back. To the environmental community, CEQA is an important, perhaps the most important law protecting the environment. As a result, they're expressing concern over making wholesale changes to that law. One of the key spokespersons is Bruce Resnick, Executive Director of the Planning and Conservation League. Welcome to the Maddy Report.
Thank you very much for having me.
So proponents argue that the CEQA process is being abused by businesses against competitors, by unions seeking to exert pressure on non-union businesses, by NIMBYs who want to kill or delay projects. Is there some need for reform?
Look, I don't think any law is sacred, and not even CEQA, although it is the foundational environmental law and something that PCL helped draft back in 1970 and have been defending in the legislature and the courts ever since. The problem we have is, first of all, you got to define abuse. A lot of times the other side looks at abuse as every time they just don't get their way on a project, that's abuse. The reality is, when most independent studies have been done, you don't actually see a lot of abuse. You see a few anecdotes on the other side. We have 75 anecdotes of good CEQA success stories, a report we did in 2005 called Everyday Heroes that we're updating. So first we have to define what abuse is. The reality is, even taking all that into account, CEQA has been one of the most amended statutes. Almost 20 sections a year over the last 5 years have been amended. And the reality is, we're making it more confusing, we're making it more difficult to work. And that's one of the other complaints you hear. Well, CEQA is very confusing. Well, it's confusing because we've amended it so much. So, I think we need to pull back. It's been a statute that's worked really well. I think we need to explore where it can work better. But when I talk about reform, it is making it work better for better environmental outcomes, better community engagement.
Well, some folks also say, listen, CEQA adds a lot of cost to projects, and that hurts economic growth. What's your response to that?
Does CEQA add some cost? Yes. I grew up, my mom used to say, an ounce of prevention is worth a pound of cure. And that's what CEQA is about. It's about looking at taking your time, looking at the potential impacts, doing everything you can to minimize those impacts. Is that going to take a little bit longer? Yes. Is it going to cost a little bit of money? Yes. but the reality is you end up with a better outcome at the end. And I think it's a little disingenuous when folks talk about, the economic climate and how much it hurts jobs. Look, why is this country in an economic mess? Because we deregulated the housing industry, we deregulated Wall Street and the banking industry, and basically allowed those folks to profit while everyone else paid the cost. And that's exactly what deregulation of environmental regs do. CEQA, one of the most important things it does, in addition to good green outcomes, community empowerment, informed decision making, good governance type requirements, is it forces developers to internalize the cost of their development. And if they didn't do that, you're going to have those costs, but they're going to be born in dirty air and dirty water and toxic communities.
Well, what about legal costs associated with CEQA? And you often hear the pushback from the environmental side saying, well, listen, there are not a lot of lawsuits filed. Right. Businesses are going to respond, well, that may be true, but the threat of a lawsuit is what's driving up legal costs. What is your response to that?
A good point, and I think we both have some solid points, but I would say it is the threat of lawsuit that often makes agencies actually comply with CEQA. One of the things that we talked about, and this came up with the bill last year with 317, is, well, we want all the process of CEQA, but we don't want any enforcement. Well, what good's a law if you're not going to enforce it? I mean, the reality is you need that enforcement mechanism, and with CEQA, it is the threat of lawsuits that actually brings agencies to the table and makes sure they do their job, because the reality is, most of the time, agencies are going to try to bend over backwards to appease, a big development project, a big, industrial project. And again, that's going to often benefit those companies, but at the expense of the public.
One of the more controversial proposals is this thing called standard-based approach, where they're saying, listen, if a developer meets the city plan or the county general plan or state environmental requirements, there shouldn't be a CEQA lawsuit. What's the problem with that? If they're meeting all the environmental requirements, why add CEQA on top of that?
Well, that sounds good. There's a number of problems. First of all, there's stuff that CEQA does that no other standard does. And when people talk about CEQA and they talk about the green outcomes, well, that's true, but like I said, CEQA is so much more. It really is viewed as an environmental bill of rights. It is what gives communities a voice in the decisions. It is what gives decision makers the information they need. So if you pull just the standards approach, you lose a lot of that. The second part is a lot of standards just aren't that good. A lot of general plans are 10, 20 years old. They're out of date. They don't actually provide the protection. So CEQA is really the catch-all, and it's the fabric and the foundational law that brings those together. So the standards, like I said, it sounds good. It sounds very common sense, but a lot of really impactful projects would be getting through if you didn't have CEQA as the backstop.
What about the argument that, listen, CEQA focuses on individual projects, and that's a poor substitute for general plans that are really focused more on the cumulative or regional impacts of land use decisions?
I agree. I agree.
Okay, next question.
But the point is, if we have a problem with our land use in California, and I agree that we need to do more infill and less sprawl and all that, we shouldn't be weakening the community protections that CEQA provides, which is what the response is from the other side. We should be strengthening our land use planning. And the reality is, as much as some of the folks that are looking to weaken CEQA, they want to portray it as, these are the green projects in the infill. It really is sort of the business as usual. It's a big industry. It's the Walmarts, it's the Chevrons, and what have you. And the reality of it is, kind of, again, bending over backwards to sort of make those guys happy is really going to ultimately impact the communities. And that's particularly important in a place like Central Valley, which already bears so many impacts of air and water. And CEQA is the one thing that really empowers those communities to have a meaningful voice in the quality of their life.
Well, I want to thank Bruce Resnick from the California Planning and Conservation League, Sacramento attorney Tina Thomas, and Allan Zaremberg with the California Chamber of Commerce for joining us. If you'd like to stay current with state and local politics, you can sign up for our free and award-winning e-newsletter, The Maddy Daily, by logging on to our website at maddyinstitute.org. And now, another perspective.
One of Jerry Brown's big goals is reforming the landmark California Environmental Quality Act. The governor, along with business interests and even ordinary citizens, believes that CEQA, as it is called, slows growth and raises unemployment. Unemployment these days in California is a tick under 10%. Backers of CEQA counter that it is a model law and it has served California and the environment well. The record shows otherwise. California's air is the worst in the nation, the state is running out of water, and it continues to allow urban sprawl. Moreover, CEQA is used as a hammer by labor groups to force union contracts on reluctant developers and contractors. Now the big question, will CEQA be reformed? It'll be tinkered with, but there will be no real reform. You have to remember, anytime state lawmakers want to sidestep CEQA for their pet projects, they can. It's everybody else that has to follow the rules. I'm Bill McEwen for the Maddy Report.
The views expressed in the Maddy Report are those of the individuals participating in the program and do not necessarily reflect those of the Maddy Institute, the California Channel, Casey, or Valley PBS. If you'd like to share your thoughts about the points and opinions shared in the Maddy Report, visit our website at valleypbs.org/Maddy. This is Mark Kepler for the Maddy Report. Thanks for joining us.